Mwirori ni mukurikana interview na twekire tariki 14 mweri wa mugwanja mwaka wa 2025 iria ya muthuri uria wikaine ta Mburu wa Kinani uria hindi yo aikarite muchari makiria ma mieri 8. Ni mukurikana wega ta wega Edith akiuga ati ni meriga gutumirwo message ni mwanake wa kana ni brother ya deputy governor wa Kiambu no Rosemary Kirika, mwanake uria wikaine ta Karanja uria werire Edith ati maigite makiria ma milioni 40 nigetha makorwo magicindana na Edith na nigetha mahotane cira uyu. Muthenya wa umuthi kana muthenya wa ira cira uyu ni urarikirie gukinywo igoti-ini na bogo niguo kurathire na mbere. Tathiite na mbere reke nyambe ngutige na mĩario ya Edith ya hindi yo na uria ugaga uria undu gwitwo Karanja atumagira Edith na akamwira maigite milioni 40 ni undu wa cira uyu. Tathikiriria wĩiguire uria igoti riraugire na uria Edith augire tariki 14 mweri wa mugwanja mwaka uyu wa 2025 na niguo cira uratuirwo muthenya wa ira tariki 16 mweri wa kenda mwaka wa 2025.
Tondu ni turarikirie kumenya mibango iria ina ndware. Andu acio ni maratwandikire message through brother yao itagwo Karanja, na ndirauga Karanja ni gukorwo arakorwo atumitwo ni family yo nigetha atwire maundu macio. Ndiramwirire ni turandikirwo message cia gututhiriten no mathite na mbere gutwandikira message cia gututhiriten na nigetha tutigane na undu uyu. Maratwandikire message maratwira thiini wa account yao iria mahingurite ya cira uyu mena milioni 40. Ngikiuria andu mena milioni 40 na andu me moko matheri ri tutingigitwarana, na riu andu maregana mena milioni 40 account-ini yao ya mbeca cia cira uyu ri lakini igukioneka andu maretikira kumwira mena milioni 40 account-ini ya cira uyu.
Lady, good morning.
I said just a minute. Okay, so you are saying Miss who?
Miss Award, my lady. I hold brief for Professor Gender for the appellants who are the respondents in the application.
Oh, okay, sorry. Miss Award, holding brief for. Yes, and who appears for the applicants?
Yes, my lady, in that matter, my name is Stanley Kinyanjui.
Yes.
Together with Dunstan Omari, I can see he's online but muted. We appear for the applicants in that application that's coming up a ruling.
Okay. Anyone for interested party? Anyone? Okay. So no appearance for interested party. So this is the ruling in respect of the application dated 17th of July 2025. I will not read all of it. So the long and short of it is that the application is dismissed with costs. So first is Ms. Kinyanjui for applicant. Having said that, are you still here? Yes, you're still here. Okay, so this matter was scheduled for judgment on the 7th of August 2025 when the respondents filed the notice of motion dated 17th July 2025, which effectively arrested the judgment. The appeal relates to a burial dispute the deceased having passed away in November 2024. The deceased body continues to lie in a mortuary, awaiting the outcome of this appeal. In my view, this matter is urgent and ought to be concluded expeditiously, and for that reason, I proceed to deliver the judgment, since the ruling on the application has already been rendered. Here is your judgment.
My lady, with your kind permission.
Yes.
I had instructions from my senior.
Yes.
To ask for a typed copy of that ruling for the purposes of appealing that ruling.
No problem. Let me read the judgment. You'll get both of them. So this is let me take the quorum for judgment. Ms. Award, you appear for?
Ms. Award for the appellants.
Mr. Kinyanjui for respondents? Yes? Mr. Kinyanjui? I assume he's for the respondents. Okay, anybody for interested party? 094, anyone for interested party, Kijabe Hospital? Very well. So your judgment is as follows. It is quite lengthy. I will not read all of it. Okay, so I have carefully considered the grounds of appeal and rival submissions. This being the first appeal, I don't want to read all that. So before delving into the appeal, one issue for determination is the admissibility of the supplementary record of appeal. This issue has since been determined by the ruling of this court delivered today. Supplementary record of appeal is therefore admissible for consideration in this appeal. The grounds of appeal and cross-appeal by the appellants and respondents respectively can be synthesized into the following issues for determination. One, whether the court erred in law by assuming and exercising territorial jurisdiction over the dispute. Two, whether the deceased's burial wishes were proven to be ascertainable. And three, the applicable framework for determining the place of burial. First, the territorial jurisdiction. The appellants argued that the trial court in Nairobi lacked territorial jurisdiction to entertain the suit, given that the competing burial sites are in Gatanga, Murang'a, and Gilgil, Nakuru County. They termed the filing of a suit in Nairobi as forum shopping. The respondent countered that for a chief magistrate court, with jurisdiction throughout Kenya under Section 3(2) of the Magistrate Court Act, the place of suing is a matter of administrative convenience rather than a substantive jurisdictional bar. While Section 15 of the Civil Procedure Act dictates the local limits for institution of suits, the Magistrate Court Act is a substantive statute conferring jurisdiction. The resident magistrate court, which includes the Chief Magistrate Court, has jurisdiction throughout the Republic. Judicial pronouncements have clarified that where a conflict arises between these two, the later statute is deemed to amend the earlier one. I have cited quite a number of authorities here. More fundamentally, however, the record shows that the appellants acquiesced to the jurisdiction of the trial court. In his ruling on the preliminary objection, the learned magistrate acknowledged the administrative nature of the issue and invited the parties to appeal or object further. The appellant's counsel agreed to have the matter heard in Nairobi for expeditious disposal without preferring an appeal. Having taken their chances on the merits and lost, they now seek to invalidate the entire process. A party cannot consent, participate fully in the proceedings, and then turn around on appeal to challenge the very jurisdiction after receiving an unfavorable outcome. This amounts to approbation and reprobation, a conduct which this court will not permit. Beyond the doctrine of approbation and reprobation, this court must register its disapproval of such litigation tactics to allow a party to fully submit to a court process. Holding a jurisdictional challenge in reserve as an ace up the sleeve to be played only in the event of an adverse judgment would be to sanction an abuse of court process. It would encourage litigants to adopt a wait-and-see approach, thereby undermining the finality of trial court decisions, and clogging the appellate system with procedural appeals that ought to have been settled at the outset. This ground is therefore dismissed, not only for being unmeritorious in law, but also for being contrary to the principle of judicial economy and the overriding objective of the CPA to facilitate the just and expeditious, proportionate, and affordable resolution of disputes. B, ascertainability of the deceased wishes. The law in Kenya, while recognizing that there is no property in a dead body and a person cannot dispose of it by will, nonetheless holds that the wishes of the deceased, though not legally binding, should, as far as practicable, be given effect. I have cited two authorities. However, these wishes must be ascertainable, clearly ascertainable, specific, and unequivocal. I have cited the case of Samuel Onindo Wambi and SAN versus GW, Civil Appeal number 1 of 2020. The central question, therefore, is whether the appellant proved the existence of such a wish on a balance of probabilities. The appellants contended that the deceased had expressed, quote, express and unequivocal wishes to be buried in Gilgil next to his late wife, Magdalene Waithera. They presented several witnesses and a video recording to support their claim. DW1, DW2, DW3, and DW5 all testified that the deceased had, on several occasions, particularly around the time of the burial of his second wife, Magdalene Waithera, stated his wish to be buried in Gilgil next to her. The most significant piece of evidence was a video recording. DW7, nurse Pamela Gaki, testified that she recorded the deceased on her phone in 2020 at St. Mary's Hospital, wherein the deceased had stated his wish to be buried in Gilgil. However, this evidence is beset with profound and irreconcilable contradictions. In the certificate of electronic evidence filed by the appellants, DW8 swore that the video was retrieved from the deceased's mobile phone. DW7 testified under oath that she recorded it on her own mobile phone. Her testimony was further undermined during cross-examination, where she gave conflicting accounts of the date of recording, the language spoken, and the chain of custody of the video. These inconsistencies fatally wound the credibility of the video evidence. The respondents challenged the credibility of the oral testimonies in cross-examination. They highlighted inconsistencies regarding who was present during these alleged declarations. For instance, DW3 initially stated that he was alone with the deceased when the wish was expressed, but later added that Magdalene Waithera was present. DW5 added other individuals to the list who were not mentioned by other witnesses. DW1's testimony regarding the deceased pointing at a burial spot was questioned due to the ambiguity of a photo and the lack of a visible grave site. DW3's account of the deceased wishes also lacked specificity and corroboration. The respondents also highlighted that the narrative of estrangement and the alleged attempts to poison the deceased were not sufficiently proven. While the appellants presented a consistent narrative through multiple witnesses, the severe credibility issues surrounding the video evidence, coupled with the inconsistencies elicited in the oral testimonies, means that this court cannot, with the requisite degree of confidence, find that an express, unequivocal, and verifiable wish was proven on a balance of probabilities. I have cited the case of Johnston Kasi Mumbo and Florence Maweu. Given the conflicting testimonies, inconsistencies, and lack of clear corroborated evidence, this court finds that the oral wishes of the deceased regarding his burial place have not been proved to be unequivocally ascertainable. The trial court's finding that the wishes of the deceased could not be confirmed or verified is therefore upheld. In the absence of clear wishes by the deceased, what then is the applicable law? Both parties acknowledge the applicability of African customary law in burial disputes, provided that it is not repugnant to justice and morality or inconsistent with written law. This is enshrined in Section 3.2 of the Judicature Act, where the deceased wishes are unascertainable or unproved. The court must turn to other principles to resolve the dispute. The main competing frameworks advanced by the parties are Gikuyu customary law and the doctrine of personal and legal proximity. The respondent's case is founded on the assertion that Kikuyu customary law dictates that a man be buried at his ancestral home next to his first wife. The appellant, on the other hand, argued that the deceased had embraced a Christian life, contracted a statutory marriage, and had, for all practical purposes, abandoned the customary way of life that would necessitate a burial in Gatanga. The present case is a classic example of the tension between customary law and the realities of modern life. The law does not exist in a vacuum. I have cited the case of Sakina Sote Kaitani. And in the absence of ascertainable wishes of a deceased, customary law generally prevails. I've cited the case of Martha Wanjiro Kimata and another. The doctrine of proximity, as articulated in the case of Ruth Wanjiro Njoroge versus Jemima Njoroge, identifies the person with the fundamental proximity in law to the deceased as having the color of right of burial. The evidence on record is overwhelming in this regard. Firstly, it is not in dispute that the deceased lived in Gilgil for over 4 decades. The chief's letter dated 26 November 2024 confirmed Gilgil as his last known place of residence. The deceased established a home and even buried his second wife there. This was not a temporary sojourn, it was his life. As was held in Onderi versus Ontweka, where a person has established a home away from his ancestral land, that choice must be respected. Secondly, the deceased contracted a statutory Christian marriage with Magdalene Waithera on the 14th of March 2020 at a church in Gilgil. This was after almost 37 years of enjoying a union with her under customary marriage. This created a primary legal bond with his second wife and her children, the appellants. Thirdly, the evidence contained in the supplementary record of appeal paints a clear and damning picture of the irretrievable breakdown of the relationship between the deceased and the first family. In a letter dated 4th November 2009, the deceased stated that following the mistreatment by the first wife, he had decided never to return to that house. A corroborating letter from Phyllis Wanjiro stated that she no longer wanted to live with the deceased. A further letter dated 5th November 2009 by Joyce Mudhoni confirms her mother's unwavering decision to separate. Such conduct, as held in Edwin Otieno Ombajo versus Okumu, can extinguish a party's customary right to bury the deceased. The first family's long alienation from the deceased, contrasted with the second family's care of him in his final years, speaks volumes about where his attachments lay. This court places significant weight on the documentary evidence. Unlike oral testimony, which is susceptible to the frailties of memory and the influence of present interests, the letters from 2009 provide a clear and untainted window into the reality of the relationship between the deceased and his first family. Their contents are far more persuasive than the contested oral evidence presented by both sides regarding state of mind. The repugnancy clause in Section 3.2 of the Judicature Act is not a static concept rooted in colonial era notions of justice. It must be interpreted through the lens of the values enshrined in the Constitution. These values include the protection of individual dignity, freedom of association, and the right to choose one's residence. The deceased, over a period of 4 decades, exercised these constitutional freedoms. He chose to establish his home and family in Gilgil. He chose to enter into a statutory marriage, even after more than 30 years of a customary union. He chose to be with the second family. He chose to bury his second wife, Magdalene Waithera, there, where a grandchild had been interred earlier, to apply a rigid customary rule that effectively erases these profound, lifelong, and constitutionally protected choices would be to diminish his dignity in death. The application of that specific customary norm in these specific circumstances is therefore repugnant not just to an abstract sense of fairness, but also to the concrete values that form the bedrock of our constitutional order. It is therefore my considered view that the trial court erred in law by prioritizing a contested customary norm over the deceased's lived reality. This court finds that the fundamental proximity in this case is overwhelmingly established not by a single factor, but by the confluence of the deceased's entire life narrative. This includes the legal proximity created by his statutory marriage to Magdalene Waithera after the demise of his first wife, the geographical proximity of the 4-decade residency in Gilgil, the familial proximity evidenced by his life with and care by the appellant in his later years, and the emotional distance from the respondents demonstrated by the clear documentary evidence of estrangement. It is this holistic view of a person's life, not a single reliance on contested customs or past legal status, that must guide this court in determining where he should be laid to rest. In the premise, the appeal must succeed. Before giving final orders, it is crucial to remind the parties that a burial dispute has no bearing whatsoever on rights under the law of succession. Many a time, parties cling to the corporal remains of their loved one and to the grave, assuming that this, in one way or another, gives them more rights over others when it comes to succession. Nothing could be further from the truth. Finally, I wish to borrow from the words of the trial court. I am fully alive to the fact, and I quote, I am fully alive to the fact that whatever the outcome of this case, there will be one party of a family that will be unhappy with it. I, however, wish to point out to the parties that the intention of this court is not to cause more divisions. It is hereby ordered that, 1, the appeal dated 17th June 2025 is hereby allowed. The cross appeal is hereby dismissed. The judgment, 2, the judgment and decree of Honorable G.M. Gitonga delivered in Milimani MCFCE 081 of 2024 on the 12th of June 2025 is hereby set aside in its entirety. 3, the final resting place of late Mburu Kinani shall be his farm in Gilgil, Nakuru County, next to the grave of his late wife, Magdalene Waithera Mburu. 4, the burial shall be conducted in a manner that respects the deceased's Christian faith and his Agikuyu heritage, with the specific arrangements to be led by the appellants, who shall accommodate the participation of the respondent. 5, the interested party is hereby directed to release the body of late Mburu Kinani to the appellant. 6, both families shall have the right to participate in the funeral arrangements and the burial ceremony. And 7, considering the nature of this dispute, each party shall bear its own costs.
We are much obliged, my lady.
Fiona will be speaking the typed proceedings and typed judgment of this honorable court.
Typed proceedings and judgment.
Yes, Your Honor.
Shall I include ruling?
Yes, Your Honor.
Okay. Very well. So,
Your Honor, I'm constrained to seek for stay.
And I am constrained to ask you to file formally. You know that I'm now functus official, right?
Yes, I know that, Your Honor.
Yeah. So you have to,
as you direct, we are most obliged.
So you'll be furnished with copies of ruling and judgment and typed proceedings. I believe for that you have to write and pay. Yeah?
Yes.
Okay. And with that, I proceed to close the file.
We are much obliged, my lady.
Please go and bury the man.
We will, my lady.
Next.
Mwiroreri thengia wa cira ũcio gũkorwo ũgĩtuo mũthenya wa ira kũrĩ tarĩki 16 mũthenya wa ũmũthĩ kũrĩ tarĩki 17 famĩlĩ ĩrĩa ĩngĩ ĩrĩa ĩtongoretio nĩ Deputy Governor wa Kiambu mũthenya wa ũmũthĩ nĩ matabanirie mathiko na mathiĩ mathika ũrĩa warĩ baba wa Edith. Nĩ mũkũririkana Edith kana nĩ mũkũririkana Deputy Governor wa Kiambu nĩwe Rosemary Kirika agĩtarĩria atĩ o nĩ gũthiĩ mathire na magĩkora mũthuri wĩna indo. No mũthuri ũcio makorire wĩna indo, mũthuri ũcio athikirwo mũthenya wa ũmũthĩ na athikirwo na njĩra ya kũmakania mũno. Na andũ arĩa makorirwo magĩthiĩ mathiko nĩ famĩlĩ ya mũtumia wa kana, no matinakuruhania famĩlĩ ya mũtumia wa mbere na ciana ciake. Gũtirĩ mwana ona ũmwe ũthire gũthika baba wao. Arĩa mathire gũthika mũthuri ũcio gwĩtwo Mbũrũ wa Kĩnani nĩ ciana iria ciokire. Ciana ciake ciothe cia mũtumia wa mbere, wa kerĩ na wa gatatũ, gũtirĩ mwana ona ũmwe ũkorirwo ũgĩkinyia mathiko macio. Hihi nĩkĩ gĩtũmire famĩlĩ ĩno ĩteng'erie mathiko ũguo na yage gũkuruhania famĩlĩ ya mũtumia wa mbere, ona thengia wa igoti kuga nĩ mabatiĩ gũkuruhania famĩlĩ ya mũtumia wa mbere? Hihi nĩkĩ kĩrarĩa kĩrĩa kĩngĩ? Kwĩna ũhotekeku atĩ mbeca iria ciaragwo mirioni 40 nĩ irarutire wĩra. Nĩ mũkũririkana rĩrĩa cira wa mbere rĩrĩa kwerĩtwo atĩ mũthuri ũyũ agũthikwo gũkũ mwena wa Gatanga, famĩlĩ ya mbere ya mũtumia wa mbere ĩrĩa tongoregio nĩ Edith nĩ ageririe gwĩta famĩlĩ ĩno ĩngĩ ya kerĩ nĩgetha makorwo magĩthika baba wao. No handũ wa famĩlĩ ĩno ĩngĩ ya kerĩ moke manyitanĩre, mateng'erire igoti-inĩ na magĩthiĩ kũhingithia ndeto ĩyo matakwĩra famĩlĩ ya mbere. No rĩrĩa o mwena wao mahotana cira ũcio, matindakorwo magĩkuruhania famĩlĩ ĩno ya mbere. Ingĩ gũtereba ngũririkanie njĩtagwo Wandua wa Mwangi.